So, morning everybody, and welcome to March's coffee break briefing. As always, I'm Chris, one of the employment solicitors here at Frettons, and I am joined this morning on a slightly different session by Nathan Andrews, our head of HR services. I will let him introduce himself properly in a moment. As we know, this is the 17th, 18th one of these that we've run now. Last year, working through the employee life cycle. And as I've said in some of the start of these ones, this year we're doing things a little bit differently. We're doing topics as they arise, topics that you have suggested, and things that we think are going to be interesting, novel, or something slightly different to explore. Session is recorded, as you've probably noticed. It does become available through the Frettons YouTube page. It's circulated, I think, to everybody who is signed up for it. And we do often have a kind of summary document that goes out as well, talking about some of what we've discussed. Slightly different format today. As I said, I have got a co-presenter with me, so rather than being presentation style, there's not going to be any slides, there's not going to be any content in that sense for this one. It's largely going to be Nathan and I having a chat about the topics and talking about the kind of work that we both get involved in, the way we work together and the way that we can work with you. The content that came out then, we're talking about the relationship between HR practice and the legal advice sector, how HR professionals and employment lawyers interact and work together. And then towards the end of the session, some common areas for good HR practice, some of the things that are cropping up a lot for us at the moment. As always, all the way through this, we've got access to the chat, to the Q&A, so please do chip in, please do give your opinion, please do ask questions at any time. That said, I said I'd give Nathan an opportunity to introduce himself. He's had 3 minutes waiting and working out what he's going to say. So Nathan, over to you. Who are you?
Thank you, Mr. Dobbs. Good morning, everyone. Most of you may or may not know me, as the case may be, but I think most of you probably will know me from my post on LinkedIn, and I've probably met some of you over the last 10 years where I've been consulting my own firm. I joined Frettons back in July last year. So I'd spent 10 years running my own firm, decided I wanted to make a change, brought my professional practice over to Frettons, and I've set up camp with Chris, poor Chris. Yeah, he now has to put up with me, don't you, Chris, when you visit the office? But we thought this might be a good opportunity just to talk a little bit about the work that I do alongside Chris and Michelle and Kate, because we've had lots of interest, and I still have lots of people ask me questions about the work that I do and how that sits alongside what Chris does from a legal perspective. So, as I say, I joined the firm in July last year as head of HR services, and the remit of my role was to come in and to develop and offer complementary HR services that could sit alongside the legal work that Chris, Michelle and Kate will do as employment solicitors. So my background has always been in employee relations, so that's kind of my area of expertise, the area that I've chosen to specialise in under the HR umbrella. And so a lot of my work is focused on HR case management, but I also get involved in conducting complex investigations for clients, and I'm also a trained and accredited mediator, which means that I can offer mediation and conflict resolution services to clients. So just to give you a bit of a breakdown of what all of that means in practice. So if we talk about HR case management and how that works, essentially what I do as a case manager is I will support client organisations on various matters. It could be handling matters related to long-term sickness absence, it could be short-term sickness absence, it could be performance management, may even be disciplinary and grievance issues. But the work that I do is whilst it obviously is heavily influenced by employment law, I mean, needing to draw on my knowledge of employment law, it's much more of a hands-on role. So I will support clients with the operations of the disciplinary procedure, for example. So if they need a guidance on what a disciplinary procedure should look like, what steps they need to take to make sure that they're following a fair procedure, that's where I will step in and support. And occasionally, and actually more often than not, if we get complex cases, we will have case reviews with Chris, for example, if we think that there might be the potential for a claim, and we want to rely on Chris's legal knowledge to be able to give an opinion from a legal perspective. That's where we kind of dip in and out from a case management viewpoint. But case management is essentially a service that is designed to help clients organise information, assess that information, to make robust decisions about how they handle employment decisions within the workplace. So my work really goes right up until the point that maybe an employee has left an organisation or they've been dismissed and and there's potentially going to be the risk of a claim. So I work alongside either clients who have existing HR teams, or and we have lots of clients that don't have HR resource, so they will outsource to us. So that's where our case management service comes in handy. It essentially enables us to work with that client, and we can do that one of two ways. We either work as a background advisor, where the client will say, actually, I'm quite confident to deal with this myself, but I would just value the guidance from an HR practitioner. Or we can do much more of a hands-on approach, where the client will say, look, I actually haven't got either the resource, or I don't feel confident dealing with this, or, as is often the case, they will say, look, what, I'm a small organisation, I don't want there to be any issues around, bias in this process, so can you step in and manage it for me? And we'll do just that. And actually, that's probably one of the key differences, isn't it, Chris, between what I would do as an HR practitioner versus what you would do as a solicitor. I'll get my hat, roll my sleeves up and actually get involved in maybe more of the doing on a day-to-day basis, where Chris, you need to obviously keep yourself more distant from that from when you're advising from a legal perspective. Is that fair?
Yeah,
I think that's fair.
yeah, absolutely. I like the way you were just about to say, get your hands dirty. But we've said it before, and I've said it on training sessions before. HR, whether internal or in sort of your capacity in a more external provider, is very much at the coalface. It's easy for us as legal advisors to sit here and say, this is what the law says, this is what's going on, this is a recent case law update. The question is, what do you actually do when you're dealing with this in reality, when you've got somebody sat in front of you? So, I mean, that being the case, thanks for the intro, of course, Nathan. I think that was useful for everybody. And the more we can make sure that people understand what you do and that you're not our internal HR provider, the better.
Yes.
It probably leads quite nicely on to the first topic. And like I said at the start, I think this is probably going to be quite a fluid conversation, quite a fluid discussion. Our first two topics we said we'd cover today is the relationship between HR practice and the law, and kind of how HR professionals and legal advisors work together. So we've started with that already to an extent. I suppose a sensible place to start then with maybe a more detailed conversation about that would be what your kind of experience of how that role works and how those two roles interplay.
Yeah, I mean, certainly I spent many years at the front end of my career, probably the first 10 years of my career in-house roles, so in-house HR manager roles, head of HR roles, and I would spend a lot of time obviously working within the organisation as a generalist practitioner, and what I would often do is partner. Really, I always saw it as a really meaningful business partnership with external law firms, and where that came into its own for me was that I would be handling issues, whether it's organisational restructures, which could see mass redundancies or even small scale redundancies. We might have complex issues where I thought, actually, I've got an issue that I think is realistically going to become quite contentious. It could result in a potential claim. We might want to look at a settlement agreement. So I would always rely on my external lawyers to give me their legal guidance from early on. Really, for me, I always found as an internal practitioner, it was really helpful to recognise when there might be an issue, and actually to be really proactive and not wait for it to become an issue, where I then needed to pull in an employment solicitor to say, actually, I've got this issue. It's feeling quite urgent. It's becoming quite disruptive to the business, and I need that support. So I always try to be really proactive and really weigh up early on when I needed to get in that kind of external expertise or legal advice. And I think that's something that, and I see this in some of the consultancy work that I do, where when you're in an in-house HR role, you're busy, you're under lots of pressure, you've got competing priorities. But actually, we often see, don't we, Chris, where sometimes reaching out and actually working with an external employment solicitor early on has been missed, and therefore things become quite much more difficult, viewpoints become much more entrenched. So the partnership for me, certainly when I draw back to my in-house days, was building a relationship with somebody who knew how I like to work. So they knew me, they knew the business, they knew our culture, they knew what we wanted to achieve there, and they also knew how we like to manage our employee relations cases. And then I used to make sure I had regular dialogue, and if I thought, actually, I've got a grievance that looks like it's going to be tricky, I'd get on the phone, and I'd also own it if I thought, actually, there have been some errors, we might have had issues with line management that maybe have contributed to that situation. I'd put that on the table and have a really meaningful conversation and agree a way forward, and that's always worked really well for me. I don't know if there's anything you want to add to that from your perspective, Chris.
No, but I think it is about knowing where that touch point needs to come in and not
Yep.
being perhaps too scared or too concerned about going in too early and risking having that conversation. You talked about examples of kind of organisations who don't have that internal HR function. I do sometimes wonder whether there is, and I know we've got a couple of other HR practitioners on the call, so please do chip in if this is your experience as well. There is sometimes that fear about the escalation, the cost of engaging with an employment solicitor at that point, even with HR, to be honest. And an element of this is something we'll handle ourselves, let's get it over quickly, let's get it done and sorted, but without maybe that knowledge or that objectivity. And I think, where you said that there were maybe missed opportunities in cases that we've seen, and I can think of several examples straight off the top of my head, as I'm sure you can. What do you think then, I suppose, is that obstacle? What is stopping people from engaging that way, whether it's with an HR professional, such as in your case, or one of the many others who are on this call, or maybe with us as employment lawyers?
Yeah, that's a really good question. I think sometimes, and again, I'm going back to, and I mean, it does apply to my time spent consulting, but certainly go back to my corporate days when I was in house, cost sometimes was always an issue. So there would be kind of budgetary constraints and how much we're spending on legal this year. I mean, often I found that we never were realistic enough with actually assigning an adequate amount in the budget for legal services. So I think cost was definitely one of them. Sometimes I think HR practitioners can put a lot of pressure on themselves to kind of be that unofficial lawyer within their organisation. There was an expectation, I think, on all of us that we have good, robust knowledge on employment law, and I think we all do. But the reality is, and I say this, and I'm drawing on my consultancy experience, where I've worked with in-house HR teams, where I'll say to, those people, actually, you can't be expected to know everything. And if that is a barrier for you reaching out to an employment solicitor, thinking, actually, should I know this? Actually, no, you're not supposed to know everything, and we're certainly not supposed to be employment solicitors. We've been trained in a very different way. Yes, we have good, robust knowledge of HR and employment law, but the way we advise is really around those processes and procedures. Yes, we draw on employment law knowledge, but it's not the Chris will have. So I think I don't know whether that is a barrier for everybody. I know certainly I've spoken to HR teams and certainly practitioners who have worked with me from an employee relations perspective, say, I feel that I should know this. And actually, I would say that if you're in a generalist HR role, you've got a huge amount of information that you've got to work with, whether that's looking after payroll, developing training and development programs. Employment law is one aspect of HR management, and I think for me, certainly when I was in-house, I gave myself permission not to always have to be the expert, certainly when I was a generalist HR manager, because the scope of the role was so broad that actually I thought, no, I'm not going to allow that to be a barrier for me. So there were things that I used to work with a lot, and obviously there was pressure from my senior management colleagues from the board, who would obviously scrutinise the HR budget and say, well, actually, why are we spending so much on employment solicitors? But actually, the reality is, and I'm thinking back to my time as in-house HR manager within a manufacturing company, we had lots of ER cases, and some of them were complex, and we had issues that needed to be dealt with. And actually, my view always was being proactive and using the services of an employment solicitor was actually probably more cost effective than waiting for claims to come in.
Yeah, and I think you raised two really important issues there. Firstly, the scope of the expectation on a HR professional, whether they're working in-house or whether as a consultant, like you say, it's such a broad area. It's easy to think of it sometimes as just the disciplinary, the redundancy, the grievance manager, the kind of ER side. But if you're also, particularly as a generalist, particularly as an in-house, also then advising on, you're part of the remuneration committee, you're part of the comp and benefits team, you're advising on L&D on top of all of those other sides. It's such a broad area. And there's so much of that where, as a lawyer, you might come to us to say, can you deliver the training on this? Can you advise us on the implementation of this particular benefits package? But you're not going to come to an employment lawyer to talk about a 360 review, for example, or to implement and plan or strategize an entire new course of L&D. There's, and I'm overlapping into my next point as well here. There is a difference in what you're looking for from these two types of professional, isn't there?
Yeah.
The point is, and I think it's a distinction almost between the guidance role that I think is fundamentally HR, and the more regulated advisory role that I think is where it starts to come to us. You know, as you said there, there's a risk, I think, particularly in small organisations, and particularly maybe where somebody functionally has an HR remit but is maybe not trained or qualified to be one, of becoming this sort of accidental advisor. We all know a little bit of knowledge is a dangerous thing. And I'm not trying to patronise the people who do that, and I don't think it is patronising to say this. It's about recognising the limitation of what you're advising on, as much as I would if somebody came to me and started talking about comp and remuneration packages. I can advise you, I can give you my thoughts, I can give you a commercial opinion, but that is a HR function, I would have thought. I suppose that kind of ties in nicely to an extent of there is obviously an overlap in these two roles, and there is increasingly, I think, a requirement to work together. Employment law, HR practice are complicated, ever-evolving areas where we know things change all the time. Look at all of the updates just in the last 24 hours on what may or may not be in the Employment Rights Bill, for example. Just as an example there, it's a huge amount of information in an area that changes all the time. So, as I say, these are two overlapping professional areas that have to support each other, but also have to know what each other needs and wants at the point when you instruct. So I suppose this is starting to lead us nicely into what is almost the second topic today, and how these two professionals work best together. We've sort of talked about identifying the overlap of what that relationship looks like. But, well, tell you what, throw this straight at you. You've been in practice. You've been in practice both as a consultant and kind of in-house. What was it you were looking for when you spoke to an employment lawyer?
It was always clarity around really complex matters that I knew were going to become contentious. And I thought, actually, I know what employment law says it is saying in terms of, this is what we must comply with. But actually, the thing is with employment law, there's always kind of grey areas. It's quite nuanced. You having to take, employment law. If you just took employment law as it was and think, actually, that's that one size, one size is not a one size fits all approach. Every case, every situation is different. And actually, what I found early on in my career is that
where I hold my big "it depends" line, sort of our classic answer.
Yeah, exactly. And it's actually trying to take employment law and make sense of it with relevance to your situation and the situation you're dealing with. So for me, when I would pick up the phone to an employment solicitor, I'd say, look, I get, I don't know, we just use redundancy. I get what a redundancy process should look like, but actually, this is what we're trying to achieve as our business. This is the uniqueness of our situation. Can I talk to you and get some advice around what we need to be aware of? So for me, it was always looking for that specialist legal opinion on what we were trying to achieve in our business with our situation, and making sure that any of those nuances, any of those grey areas were picked up early on, and we could discuss it and make sure that whatever we were doing was going to be, as risk-free as possible. And I know there's no such thing as completely, zero risk in anything. But for us, it was always about, when I was in house, and certainly even as a consultant, it was really about getting clear on those little issues that you might miss, that an employment lawyer wouldn't miss, because you're in the tribunal, you're in the case law all the time, much more in depth than we are as HR practitioners. So for me, that was what, as an in-house HR manager, I always relied on that. I could organise a redundancy process or procedure, but actually what I wanted to know is that the uniqueness of our situation, were we going to trip ourselves up, and was there anything we needed to be aware of? And that was hugely beneficial. I think that all makes and even case management, Chris.
Yeah, here's this quirk, here's this particular situation that's arisen, as you say. You're not going to need an employment lawyer to hold your hand through a redundancy process. Of course you're not. But we've got this individual who, having just started consultations, decided to tell us she's pregnant. We know the law has changed on this recently. What are our obligations at this stage? Or whatever other quirk may arise. And then similarly in a disciplinary situation, it's always kind of this, I suppose, sense checking element when it's still in house, isn't it?
Yeah, and I tell you, it's really it's a really good point, isn't it, around that whole just sense checking to make sure that actually what I'm reading, so what employment law is telling me, am I interpreting that in the right way, and am I applying it correctly to the situation that I'm dealing with or trying to resolve? And I think for me that's really important, is making sure that before we go ahead and proceed, we're just clear on, yes, we are applying that in the right way and our thinking is aligned, and that as if it's as risk free as you can get it. Or there might be things we have to achieve in organisations. I'm sure the HR practitioners on the call today will have been in that situation where we accept that we're there's an element of risk to what we're doing, but there's a reason why we need to do it. And so what I would always do is pick up the phone and say, actually this is what I need to achieve, talk me through how I can best do that minimises risk to the business, and then you weigh up your options. And I think for me as an in-house practitioner, certainly I wanted to know before I was doing anything that I was clear on what the risks were, that I was clear on how I was applying employment law, because I think employment law is probably one of the more complex, more academic seats in law. I don't know whether you would agree with that, Chris. I think it's certainly not as straightforward as other areas of law, and for me I needed that reassurance.
Yes, I mean, I suppose as Nathan was sort of alluding to there, employment law is one of those, I suppose, quite he was saying academic and complicated. I think it's one of those areas that draws on so many other areas that you have to develop this very very broad stroke approach to whatever issue you're dealing with at the time. It's as an area, it combines principles of contract law. As we know, I've done sessions where I've talked about the employment relationship as a contractual one. It draws on, of course, discrimination law, and I think that's what really makes the employment jurisdiction so particularly complicated. As we all know, when employment tribunals were originally set up as industrial tribunals, I think the intention at that time was to really try to simplify the enforcement process of employment rights. And I think what was probably envisaged at the time is that most claims would be pay disputes or unfair stroke wrongful dismissals or breach of contract. Welcome back, Nathan. I've muted you just so you're aware. And of course, what actually happened with the industrial tribunals and the employment tribunal is it started to escalate towards being more about discrimination claims and complicated matters that sort of arose from those situations. The vast majority of discrimination issues are ultimately social issues, and they're seen in the tribunal first. Drawing back to what Nathan was alluding to in the end of what he was saying a moment ago, yes, employment law is this very broad, very academic, constantly changing area where the big cases that we see moving forwards, the big issues are primarily social ones. Where was the menopause being addressed first? In the employment tribunal. Where was the trans debate being addressed first? In the employment tribunal. And I think that's what makes it quite complicated, and where those quirks do arise. And yes, drawing back to what we were saying earlier, if you're a generalist HR advisor and you've got to split your time between knowing that, understanding the black and white law, dealing with onboarding, dealing with recruitment, dealing with termination, dealing with L&D, I agree with what Nathan said. There's no expectation, and there shouldn't be an expectation for any of us to have that full and comprehensive knowledge. One of the most difficult things you can do in certainly training as a lawyer in any area is learning to use the phrase, I'm not entirely sure off the top of my head, let me go away and check that. And I think it's true in HR as well. There is this expectation that if you're invited to a board meeting, for example, to give an opinion on something, that you have that answer there and then. And that's not always true.
I just wanted to quickly touch actually on something, a point you've just made, actually, Chris, which I think is really important. When you talk about discrimination law, that's a classic example for me. It's such a complex area of law. We all know, I know, discrimination law, and I know the framework around discrimination law, but I will always, even now, and I specialise in employee relations, I will always seek, if I'm working, with Chris and you're in the office and we've got a case, I will always check in with Chris on discrimination law, because it's so complex that I want to make sure that if we've got a client and we're case managing something for a client, that we're doing everything we need to do to support that client and give them the best possible advice. And as again, a really important point around this pressure to as an HR practitioner to have the answers. And I think it's really important that we don't allow ourselves to feel that pressure, because the reality is we can't always know everything. We can't always have the answers there and then. And the one thing I will always own is actually I might need to go away and ponder on something. I might need to go away and look at that. You know, we all know where to find the answers, and I think that's the important thing. Is if you don't have that information to hand, it's about knowing that you know where to go to get that information. And for me, I mean, I'm lucky I have Chris in the office. I have Michelle in the office, so I can literally go over my shoulder and say, "Hey, Chris, can we just talk about this particular issue?" But you know, equally, and I know you work in this way with your HR contacts, don't you, Chris? And that you know you're always there to pick up the phone and to offer a bit of advice, and I think that's really important. So yeah, I think that again, it just touches on the differences between the roles, you know, around you know what HR practitioners should know. Certainly, when you're in a generalist role, I think being in a generalist role is a tough gig. It's something I moved away from years ago. I enjoyed employee relations work, so that was where I've chosen to specialise in. That's why I spend all my time developing in. So I sit and will read through an employment law book, and that's part of my development plan. But if you're in a generalist role, it's a big ask. And I remember doing a piece of research as part of my training around the validity of the role of an HR generalist, because I just felt that actually when you're a generalist practitioner, there's so much pressure to know, you know, a broad range of you know, topics and information within HR. When you look at the specialisms listed on the CIPD profession map, you know, it's a lot. It's a tall order. But yeah, that was my contribution at that point, Chris.
I've been there as well. I spent my first 2 years qualified in general legal practice as well. And I can remember, I always use it as an example, for the same pair of clients, I was simultaneously dealing with a matrimonial dispute, an employment dispute, drafting their wills, and a property transaction. And I was doing that kind of across the board. And, you know, it's a comparable exercise, isn't it? The expectation on you to know so much about these 3 or 4 that are actually very, very distinct areas. And as you say, discrimination compared to comp remuneration and benefits and, you know, L&D or onboard, they are very, very different areas of practice. And yet, drawing on what you said a moment ago, if what I am there for, whether it's for you or for a client, is that 5-minute check-in, that 5-minute sense check, then fine, I'm doing a fundamental part of my job by doing that. You know, nobody's saying that every time an issue arises, you're going to have to spend £500 getting an hour and a half advice from a lawyer. It may well be that you've got that one very quick question, and I think that's probably the part of my job I enjoy most, is that sense check call that can be 5-10 minutes where I confirm you're right, probably, because most of the people I talk to are. You've got the reassurance at that point, and we've all done our job. And I always think that's a good thing. I like that part of my job, really, I have to say.
Yeah, well, I suppose it's nice to be able to support people who have got similar knowledge to you in terms of, you know, that employment practice piece. You know, maybe not so much the depth of law that you have, but certainly from an employment practice perspective, it's nice to be able to work with those individuals and actually, as you say, confirm that their thinking is in the right place. I know we have, you know, through the case management work that I do, I'll spend time with Chris. I'm very you know, I apply proper case management methodology to the way I work. So our case management service, there is a proper case management methodology that I will follow. But part of that process is knowing when we escalate cases up. And, you know, Chris and I are working on how we review cases and do what I would call case management reviews. And so if I'm handling a particular issue and I think, actually, you know what, I want to sense check this, we know I'll have a review with Chris. We'll talk through what you know, the particular case that I'm working on, what you know, what I know, what I'm doing, what I think the next step should be. Then I'll talk to Chris and say, what do you think? What, you know, what are the risks? Is there anything I'm missing? And that really is such a, you know, a valuable part of what we do now working together, because it's a seamless kind of process, isn't it, where you can dip in, sense check. And there's no, you know, I don't put myself under pressure thinking, actually, should I know this? Because my view is, look, I'm really knowledgeable. I'm comfortable with the knowledge I've got. You know, and the way I work with clients. But, you know, but it is nice to be able to work alongside you, Chris, and actually be able to go through that process. And I think whether we're doing that together as a team, or whether we're offering that to you know, other HR consultants or in-house practitioners, I think it's a really useful way of working together, but also showcases the differences, because there is, and I often get asked this question, you know, what is the difference between you and an employment lawyer, other than HR consultants tend to be, you know, from an external perspective, cheaper or more cost effective. I mean, actually, the reason that is because there is a difference. There's a clear difference between what we do, but we work really well together. And actually, from a from a client perspective, I think it works really well, and it'll be the same if you're an in-house practitioner. If you're partnering with a really good employment lawyer who knows your business, understands your culture, understands your approach to handling employee relations issues, then actually it's a partnership that works really well, because whilst you as an HR practitioner go and get your hands dirty and get stuck into making sure that those processes run smoothly, you're following employment law, you also know that you've sense checked and risk assessed from a legal perspective to make sure that you're mitigating as much risk as you can. And I think that's a positive.
Yeah, absolutely. And I like this question that's just come in. I'm going to throw to you, Nathan, in the first instance. I do think
Yep.
I do think it highlights part of that difference. It says, isn't some of what we do and discuss as HR and indeed employment lawyers about psychology and asking what people are likely to do next? I'm happy to kind of start by answering that question. And yeah, there is an element of that. Of course, there is. I'm not going to pretend that I'm a psychologist. I've got absolutely no knowledge of that side of things whatsoever. My job is, in my view, advising on what is likely to happen next and applying the law to your situation. I see that as my primary function. But yes, trying to predict the way that an individual employee might react to a situation is inevitably part of that role. And I think where this distinction really comes into its own is somebody in HR practice, whether that's in-house or as a consultant, is going to be involved in that process and is going to get to know the individual. As Nathan was saying sort of right at the start, the difference between that and when the employment lawyer is involved is we've got that degree of objectivity. We don't get to know that individual. We don't really get a feel for them other than via you. And in this kind of situation that I'm sort of envisaging, this is a potentially brewing claim. Let's frame this as there's a disciplinary process or some kind of sickness absence procedure going on. I mean, my advice is always going to be, if X happens, then Y. Whereas I think the difference is, like I was saying at the start, the HR function is much more cold-faced. It's much more reactive, actually, to a specific thing that is happening in the moment. So yes, while I think there is obviously an element of psychology in debating what an individual might do next, I think that falls more on your shoulders than it does ours as a lawyer.
I would agree with that, because I think essentially what we do, and certainly what I did as certainly as an in-house practitioner, where I was working within, with management teams, supporting them in how they manage their employees, is you get to build a rapport, a relationship with employees. You get to know a bit about their personality, and I think what I would often spend my time doing is really thinking about, actually, if I do this, how's that person likely to respond? So for me, it was always thinking about their response. How is someone going to respond to this piece of information, or to me telling them that there's going to be a disciplinary hearing, or to me saying, actually, we want to have a conversation with you about your performance because we have some concerns. Is how do I think that person's going to respond? And and it's like anything, with experience, you get better and better at being able to kind of have a viewpoint on, this person's likely to respond in this way based on my experience, based on my knowledge of the person and their personality and so on. And so what I would then do is think about, can I adapt the way I'm going to deliver this message or handle this process? Can I, don't get me wrong, when I say adapt, I don't mean we ignore employment law, but it's adapting my approach. How can I adapt my approach to try and get a better outcome? So it's a really good point that you do feel sometimes like you are this kind of unofficial therapist slash psychologist, and as Chris has said, I'm not a psychologist or therapist, but it can feel like that, because when you're dealing with people, and in HR, as we all know, when you're handling difficult situations at work is such a big part of people's lives. You do get to see all the varying different emotions and responses from people, so you do get drawn into that. But yeah, I think, as I agree with Chris, and I think from an HR perspective, my experience was always, I'm looking at how people are like to respond and what issues that's going to cause me potentially, and then how can I support the individual as well as supporting the business. And I think that's the other uniqueness really within HR. And I'm sure most of you will have seen so much content on LinkedIn about how HR's not there for the employees, it's just there for the business. HR's not your friend. And actually, there's an element of truth in that. When I was an in-house practitioner, I wasn't there to be friends with people, but I was there to get the best for both sides. And I used to always approach every situation with, what do I need to deliver for the business, but how can I do that in the right way for the employees? And essentially, there will be times I'm going to have to deliver a difficult message. It might be around performance, conduct, making decisions. If I'm the chairperson for a disciplinary hearing, am I going to make a decision to dismiss somebody? Are we going to have to look at redundancies? So you are delivering a difficult message, but I would always caveat that with, whilst yes, I'm doing that on behalf of the business, I would always look at my approach and how I'm going to handle something with the viewpoint of the employee in mind. And so I think it's a fine balancing act, but it's never a dull moment in HR. I'm sure everyone can agree.
No, absolutely. And drawing on some of what you were saying there, at the end of the day, we're dealing with people, and there's so many issues that come from that. I think it's easy to forget. I suppose going back actually to how the two functions can support each other, there's a huge amount of vicarious trauma that comes from HR practice and employment law. I can certainly speak from that from acting for claimants. This kind of psychology therapist element that Nathan's alluding to comes in a lot when you're talking and dealing with an individual. Obviously not the focus of this conversation. This is all primarily about acting for businesses and tribunal stage respondents. But yes, there is that element. We're dealing with people at the end of the day. People have real lives. It's not easy to have a conversation where you're terminating someone's employment. It's never an easy conversation to have.
No.
Their reaction, they'll be unpredictable. Of course they are. I think it's possibly an answer to where do we see a lot of issues arise. And I know the naming of the service is quite controversial, but if we're going to call it human resources, then I think it's when people start to forget the human element that we start to see problems coming in. Probably leads us on quite nicely to kind of the sort of closing topic for today, which is some of these maybe common areas of things that we're seeing arising, and maybe some of our ideas around sort of good and best practice around sort of HR processes, procedures, and staff management issues. We mentioned redundancy, we mentioned disciplinary procedures, we've mentioned sickness absence. I think sickness management is maybe a nice one to share a few ideas on here because it pulls most of these ideas together. It's also one I seem to be dealing with a lot at the moment, so it's maybe worth having that conversation. I suppose the classic one that comes up, and I know those of you who have done these calls regularly, I know you sat through an entire session of me talking about sickness absence and capability. Hopefully this will give us a slightly different perspective. But I suppose, Nathan, from your point of view, sickness management procedures can be the one that is handled particularly badly. Is that a fair assessment?
That is a fair assessment, and it's so interesting. I've had conversations recently actually around, and I'm not saying this is for every HR practitioner, and I'm sure it's not, but I know with sickness absence, actually, let's go a step back a bit. It's not just HR practice; it actually can be business owners who haven't necessarily got internal HR resource. When you talk about sickness management and sickness absence, people become really concerned or wary about the topic, because I think there is so much information now, isn't there, in the news around discrimination and needing to make reasonable adjustments, and if someone's got a particular medical condition, it feels like it's going to be really complicated and overwhelming. And so actually, before we've even got started, I've often find we're certainly, when I step in with case management around managing sickness, it's often where someone's been off sick, the business didn't really know how to deal with it. It felt a bit complicated, a bit overwhelming, and so they ignored it. Thought, oh, in a month that person might be back, and then actually 3 months in, they're still off sick, and we don't really know what to deal with it. And for me, it's a really interesting one, because actually it's often where you see the most issues, and I think it's around this barrier that people put up around. It's going to be complicated. I don't really know what to do with it, so I'm going to leave it be, and then it gets a bit complicated, and then they'll get in touch with me or Chris for advice. And actually, what I always say is, with anything, start from the beginning. Be proactive. If someone's off sick, lots of short-term absence is much easier to manage than long-term, for sure. If you've got repeated periods of short-term absence, that's quite straightforward. The long-term I see is often an issue where things kind of are allowed to slide. I know you and I are having a great conversation, weren't we, Chris, around how you can have people on long-term sick leave, and suddenly you realise that someone's been out of the business for 4 or 5 months, and we've not really, they've not really had much contact. And so I support clients with this all the time, and I will always say, if you've got somebody, I'm going to focus on long-term absence, because I feel that's probably the one where you often see the issues. It's around being really proactive and actually engaging with that person, and it's looking beyond the fact they're on long-term sick leave, and remembering that this is your employee, they're your colleague, you may have worked with them for a number of years. They're going through a period where they've got health challenges, and what we need to do is to get close to them and understand what those issues are, And the best way of doing that is early doors, front loaded, sit down, have a conversation. If we know they're going to be away for an extended period, agree how much contact time we're going to have with them, how they want us to help, maintain that contact time, understanding what the issues are, making sure that they feel they can come and talk to us about their health situation, and they're not feeling like everything they say or do is going to be noted down as part of an absence management process, because in 12 months we're going to look to dismiss them. So for me, it's absolutely being proactive, not overlooking the fact that if it's looking more and more likely, then they're not going to be able to come back within a reasonable time frame. Getting advice early doors. I used to do this as an in-house practitioner. If I knew someone is unlikely to be able to come back to work within 12 months, or indeed if there were kind of signs that they might not be fit to return to work, I would absolutely be working with that person in a really meaningful way, because they're going through a tough time. But I'd also be getting advice. I'd be picking up the phone to someone like Chris saying, hey, I've got the situation. I'm not saying at this stage I want to manage this person out, or I'm going to look to dismiss, but I'm conscious that we might need to look at reasonable adjustments. What should we be offering as an adjustment potentially? What sorts of things should we be doing that we're maybe missing because we're caught up in the fact that this person's on long-term sick leave. I've got pressure from the management team to cover that kind of gap in the resource within the business. So there are all sorts of things that we should be doing proactively, and it's about, for me, I think certainly as an in-house practitioner, not getting caught up in what I perceive to be the complexity of that particular health situation, but looking at the person and making sure that I'm talking to them and being supportive and really understanding what's going on for them and how we can help. I think, and that's often what I see as an issue, is that it's not done deliberately, but I think it's that kind of the barrier comes down. We go, actually, I want to be really cautious. I don't want to say the wrong thing. I don't want to do anything that could be, seen as punitive because that person's on sick leave, and that kind of gets in the way of us doing the really good, meaningful work. Does that make sense?
It does, and I think kind of the underlying message there is it's easy sometimes to forget the purpose of sort of sickness absence and return to work processes, which is ultimately either can we get this individual back into the workplace and working well, or do we need to reach the conclusion where that is not going to happen, and therefore we're starting to work towards dismissal. It's one of those two things. But I do think it is easy sometimes to go, well, okay, this person's on long-term sick. Fine, let's leave them to it. We won't get in touch. We don't want to stress them out. We don't want to, as you say, overcomplicate the process by us getting involved further. Then suddenly it's, well, they've had their 4 weeks company sickness pay. Now they're on SSP for the next few months. And I think the problem with this is if you've got somebody who is consistently off for AN reason for 6, 7, 8 months, don't forget they've only got to prove it was likely to last 12 and they're disabled. And then we've got a whole new issue. Almost by waiting that length of time, we're starting to risk creating a new issue of whatever reason this person's been off being deemed a disability. So there is value, I think, huge value in managing these things early, and I think that's sort of the indication that Nathan's expressing there. Is it's sometimes easy to leave these things, not engage in that process, and almost kick the can. Which is understandable, why people do it. It's not a disciplinary issue. We're not saying we want to get rid of this person next week. Let's do it quickly.
No.
But it doesn't help in the long run. It doesn't help anybody.
No, I think you make a valid point in a way, Chris. I think sometimes that old saying, isn't it, about knowledge is power, really, isn't it? The more information we have, that we put ourselves in a stronger position to be able to work with that individual to make decisions about what does the future look like. I can remember years ago dealing with a really difficult situation where I'd gone into a business. There was an individual who'd been on long-term sick leave. They'd been on sick leave for, I think at that time it was about 9-10 months. Very limited contact from the business, but and that person felt really uncared for. They felt like they weren't important. They felt that I've gone on long-term sick leave. No one contacts me. They were still getting paid full pay, but the reality was when I spoke to the management team to understand, well, how has that happened? How have we got somebody on long-term sick leave that we've just not spoken to? The intention wasn't actually to ignore them or to make them feel like they were being marginalised because they were on long-term sickness absence. It was because they wanted to support them and they didn't really know how to have that conversation. They didn't want the person to feel like they were being put under pressure to return to work. And so it was a whole number of things that really culminated in this individual going, actually, I'm going through a really tough time. Work's not been supporting me. I've been kind of left on my own. And so the first thing I did was to connect that person and understand what's going on for you. What's your health situation? What do you need from us? Do you think you're going to be able to come back to work? Long term, if you think that's that's not going to happen, we're going to have some difficult conversations, because ultimately at some point we're going to have to make a decision about what the future looks like. The one approach I've always tried to adopt in managing, long-term sickness absence is being open and honest with somebody and saying, look, if we've got to make tough decisions, we've got to have difficult conversations, I want to support you through that process, because I get you're going through something as well. You're experiencing health issues, and my role here is to help support you. And people often get that confused. Excuse me. I think where there's this, you feel like you should be in supporting someone, you want to be kind to that person. You think actually, we don't want to have conversations about them maybe not being able to return to work because we feel like that's not kind. Sometimes it can be kind to have an open conversation at the right time, having taken proper advice, to say to somebody, look, it's becoming clearer and clearer from the information we're getting from your health professionals that you might not be able to make a meaningful return to work. So let's start talking about what that needs to look like. And I think that's really powerful in helping somebody to align with you and what the decisions could look like. But again, as I always say, making sure that we do follow a fair process, and that we do all the things that we should do as a reasonable employer.
Yeah, absolutely. And well, there we go. We've got our underlying message there, haven't we? Whichever of us you're engaging, that is the fundamental message. Let's make sure we're doing things that are legally compliant, that fulfill those basic tests that we're always going to apply of what was reasonable and what was fair in these circumstances. I'm conscious that we're coming down to the last 10 minutes or so, so I think in terms of kind of major discussion points, we can naturally draw a line there. There's a few questions that we'll move on to. If anybody has got any questions just while I'm doing this wrap-up bit, please do feel free to pop them in the Q&A. Anything we've talked about today, or any kind of general questions that you might have, since you've got both of us on the call for 10 more minutes. I'll come to the one that has been asked in a moment. Otherwise, Nathan, great, thank you for joining today and having that conversation. I think it's been great to get the two different perspectives on this, and I'm hoping everybody who stayed on the call has found it useful. And given the majority of people did stay on the call, I'm taking that as a good sign. For everybody else's benefit, I know you haven't had the marketing content for the next 3 sessions yet, so I'll just run through them very quickly now. Obviously, there's not a slide for them because we haven't done a presentation today. The next 3 sessions are going to be linked, and they're all going to be exploring broadly the same topic around the employment tribunal, and building from jurisdiction of the tribunal through to how a tribunal process looks, and then the final hearing and beyond that. Reason for all this, we are looking at hosting a mock tribunal later in the year in June. That will be an in-person event. You will get marketing content about it in due course. So please do keep an eye out for that. We love doing them. They are fantastically fun events, really interactive, and I think a good insight whether you've done tribunal work or not. So the next 3 sessions then, April the 2nd, introducing the tribunal, its jurisdiction, the kind of claims that get dealt with there. May the 14th, because I will be off on the 7th, we'll do the tribunal process from claim to hearing. So what happens when that claim form lands on your desk, right through kind of case management powers and what the employment tribunal gets up to. And then June the 4th, we'll be looking at tribunal judgments and decisions, enforcement and appeals processes beyond the final hearing. I'll try and get other people involved. I know Nathan has been involved in responding to tribunals, being a witness in tribunals, so we might get him on board to have a conversation about that for one of them. And then, yes, the actual mock tribunal is towards currently the mid to end of June. But again, keep an eye out for content and all of those. Please do sign up for them. The only other one I really want to mention, particularly those of you who are local to our area in sort of Bournemouth, Christchurch, we have got an upcoming in-person event on the 26th of March, which will be hosted by the entire employment and HR team. It's looking at dismissals, the fair reason for termination, and it's really going to dig into, I suppose, why we give you the advice we do when it comes to the various forms of dismissal processes. It's going to be a great event, as I say, in person, loads of information and a lunch. If you haven't had marketing content about that, please do get in touch with me. We'll make sure that you get the details. Other than that, as I say, we'll move to questions that have come through in a moment. I'll stop the recording so that we can run through those. Otherwise, thank you very much for joining us this morning. I hope you found it useful. Those of you who are going to jump off the call now, please do. Have a fantastic rest of your day, and I will see you on April the 2nd for the next one. Thank you very much.